Good evening, participants. So we are today doing third part of our webinar on insolvency resolution process of personal guarantors. And this would be the final. Today we would complete this insolvency resolution process, and we will also cover some avoidance transactions and also a little bit of bankruptcy process. And however, the bankruptcy would be a complete subject separate, and we will come out with 2 sessions of bankruptcy process, because the main process is bankruptcy process. That is very, very important to understand, because you see, before we understand bankruptcy process, it would be very difficult to take a decision for insolvency resolution process. One must understand the creditors as well as debtors. They must understand what exactly is the bankruptcy process, what are the restrictions during bankruptcy process, how the assets and how the estate of the bankrupt would be disposed of and distributed, and how the discharge would be available to the debtor. The most important part of this individual insolvency is the discharge. On discharge, which would be given to the debtor from all the past liabilities. So we have seen most part, we've seen notification, jurisdiction. We've seen that this is a 2-stage process, in fact, rather 3-stage process, because within the bankruptcy, there are 2 processes. One is the bankruptcy, and then the other is the administration and distribution of the estate of bankrupt. Excluded assets, excluded debts, application by debtor, application by creditor, the statement of affair, the report, various reports of the RP, fee of the RP, practical difficulties in RP appointment, all that we have seen, and we actually had reached till our slide, which now we have. See, the very important question that we kept it pending in the last session was what should be the rights of the secured creditors in relation to the repayment plan. This is dealt with by section 110, and there are 2 options available. The first option is that the secured creditor forfeits its right to enforce the security interest during the period of repayment plan. So whatever he is doing, it is only restricted to the repayment plan period. It is not for the bankruptcy. Bankruptcy would be entirely a different process. The secured creditor will again choose his rights during bankruptcy process. However, in the insolvency resolution process of personal guarantors, this choice would be restricted to this process only. When bankruptcy process will start, the secured creditors will again opt for his own line of action. In case he forfeits his rights to enforce the security interest separately, then he will participate into the meeting of creditors and vote as per the full admitted debt for approval of a repayment plan. Now, the only option is that in who would actually do this. So I think in case the property is very, very clearly mortgaged to some of the creditors, then those creditors would definitely like to enforce their security interest separately rather than putting it into the common hodgepodge, because the SURFACI Act is also very effective nowadays, especially for standalone properties of exclusive charge. So that actually has been very, very reasonably efficient now, the SURFACI law. Coming to the option 2, the option 2 is when the secured creditor submits an affidavit to RP at the meeting saying that he will participate and vote in the meeting only for unsecured part of the debt. The secured creditor shall also provide the unsecured part of its debt and the basis and calculation. Now, what could be the basis and calculation? Maybe because the secured creditor has an asset, he also has a valuation report, which probably he might have taken when he took this mortgage. He can actually say that the total debt is, as an illustration, total debt is 20 crores and he has a property of 10 crores. So he would submit his claim only for the unsecured part 20 crores minus 10 crores as the estimated value of the property, and the balance is 10 crores. So that 10 crore, the balance 10 crores would be considered as unsecured part of the debt, and the creditor who is not forfeiting his right, who is keeping the right with himself, would only participate in the meeting only for the unsecured debt and not for the full debt. In the repayment plan, the secured and the unsecured part of the debt shall be considered separately. And however, in case any repayment plan which is getting approved and which is also having some adverse impact on the rights of the secured creditors, right, regarding the enforcement of the security interest, then the concurrence of the secured creditor is required for approval of the repayment plan. When somebody would say that the debtor has an asset which is mortgaged to other creditor, and if a repayment plan contains a kind of resolution which is based on that property, then the concurrence of that secured creditor would be required. Option 1, relinquish the security interest in favor of the repayment plan and participate into the repayment plan, participate for full rights, full voting right. Second option, only participate in the meeting for the unsecured part of the debt. The unsecured part of the debt would be calculated based on the valuation report and based on some other calculations which the creditor would provide to RP. The repayment plan would consider secured and unsecured parts separately, and in case any clause of the repayment plan impact the rights of secured creditor, it would be his concurrence would be required. Now this is the repayment plan, and if a repayment plan is to be approved, a meeting of the creditors is required. Then after the meeting of the creditors, the RP is supposed to prepare a report under section 112 of IBC, and that report on the meeting of the creditors on the repayment plan, that has to be prepared by the RP. So what would be the contents of that report? The contents would be whether the repayment plan has been approved or it has been rejected. If approved, any modification which are made before the approval, and then an updated repayment plan with all the modifications. All the resolutions proposed, resolutions passed, resolutions rejected in the meeting, a list of creditors present at the meeting, voting records of each creditor for all meetings of the creditors. Voting record of each creditor for all meetings of the creditors would also be required as a part of the report. Any other information which the RP thinks appropriate. So that's a report. That's a report which is to be prepared by RP on the meeting where the repayment plan is considered. So that's the, as I said, there are many reports the RP has to prepare, and this is also one of the report. In fact, I would come and say that how many reports are required to be made by the RP. So now the section 1111 deals with the approval of the repayment plan by the creditors. The repayment plan or any modification shall be approved by a majority of 75% of the voting share in value of the creditors present in person or by proxy and voting on the resolutions in a meeting of the creditors. Condition number 1. So in case we see this carefully, the condition number 1, that is 75% voting share is required for approval of a repayment plan or any modification. Condition number 2, all those persons who actually would be present in the meeting or in person or by proxy, they only are entitled to vote. All creditors present in person or by proxy are only entitled to vote. Condition number 3, in case after being present in the meeting, in case they are not voting, then their voting would not be considered. So the 3 conditions, that the person is present in the meeting in person or by proxy. Number 2, now in person, of course, would also mean virtual presence in the meeting, or through a proxy presence in the meeting. Condition number 2, that he is voting on the meeting. And then thereafter, now I will take an illustration. Total voting power, voting share is 100. Out of the 100, only 80 attended the meeting. 80 attended the meeting, and out of the 80, 70 only voted for the resolution plan, and the others did not vote. They never come back. See, voting, saying yes, no, or saying abstain, this is also considered voting. But if a person is not participating into the vote, then the 70 would be considered as the total, and 75% of 70 would be the requirement for approval of the repayment plan. 100 is the total. 80 are the person present in the meeting, in virtual, in person, or by proxy. However, only 70 voted for it. Voting doesn't mean abstain. Voting also includes abstaining or saying no. Then 75% would be considered of 70, means present in the meeting and also voting. However, on the other side, in case a person is not present in the meeting in person, by virtual, or by proxy, then he would not be entitled to vote. So this clarity is entirely different from CIRP process. In CIRP, 66% is required for approval of a resolution plan. Number two, all creditors would be considered as 100. And 66% of that 100 would be calculated. In case there are people who are not voting, other than the class of creditors cases, those would be considered as no. So in the CIRP scenario, total is 100. People present in the vote in the meeting is 80. Person voting is done by 70. Then we still need 66% positive vote in value for approval of a resolution plan. However, for repayment plan, there is a way different. It's completely different. That has to be seen. Now, the approval of the repayment plan by adjudicating authority, section 114, and then we will see what is the effect of the order of the adjudicating authority on a repayment plan. I'm purposely saying adjudicating authority because adjudicating authority in this case can be NCLT or DRT, whatever the case may be. So all the sections are applicable, all the rules are also applicable. The same process would be followed by DRT or at NCLT. Now, the adjudicating authority may approve or reject the repayment plan based on the report of the meeting of the creditors as submitted by RP. So RP has submitted a report on the meeting of the creditors. Adjudicating authority may accept or may approve or reject the repayment plan. See, where a meeting of the creditor is not summoned, the adjudicating authority can pass an order for approval or rejection based on the report of the RP under section 106 on repayment plan. This is slightly confusing. It is mentioned in such a manner in the law that if there is no meeting, if the meeting has not been summoned, still the adjudicating authority can pass an order. Still the adjudicating authority can pass an order for approval or rejection based on the report of the RP under section 106. Now, there may be a case where there is only one or two secured creditor or one or two creditors. Only for the purpose of saving some time, the RP may say that I will take approval from both in writing and I will submit my repayment plan to adjudicating authority. So I would not spend that much of time which is required for calling a meeting. So in case, let us understand, it's a big formality to summon a meeting. It's a big formality to summon a meeting of the creditors. In case you can see that the date of meeting shall not be less than 14 days and more than 28 days from the date of submission of the RP's report on repayment plan. The RP shall issue a notice calling meeting of creditors as prepared under section 104 at least 14 days before the date fixing of such meeting. So all this is required when there are many creditors. Now, in case the creditors are only one or two, then the RP can take a decision that there is no requirement of a meeting. There are only two creditors and they have approved a repayment plan and they have both given an approval in writing. Why should I have a meeting? So the RP can submit a report Along in the report, the RP can always attach their concurrence on the resolution on the repayment plan, and the adjudicating authority can approve it or can reject it based on the report of the RP on the repayment plan. Therefore, meeting of creditor is not mandatory. Report of RP is required. In the report of the RP, the concurrence of the creditors can be taken by other means also, without even calling a meeting, without even summoning a meeting, because you have seen summoning a meeting is a long process. The notice period has to be 14 days, and then it has to be within 14 and 28 days. So all this is a big time consumer. So this is a big time consumption. So to avoid that, it has been empowered to RP that he can prepare a report, submit to adjudicating authority with the concurrence of the creditors. That meeting is not summoned. However, we have the concurrence, we have the approval. The adjudicating authority may also give directions for implementation of the repayment plan in that order. So now the order would be passed by adjudicating authority, maybe for rejection or maybe for approval of repayment plan, that is under section 115. When the adjudicating authority feels that there is a requirement of modification, then the adjudicating authority can also direct RP to convene a meeting of the creditors for reconsidering the plan. Where repayment plan is approved, it would be binding on the debtors and all creditors mentioned in the plan. Now, this is something which is very, very important. Let us understand it very clearly. When the resolution plan is approved during CIRP, it is binding on all the creditors of the corporate debtor. It is binding on promoters. It is binding on guarantors. It is binding on statutory authorities. Binding resolution plan. However, the repayment plan, if it is approved, it is only binding on the debtor, number one, and all creditors mentioned in the plan. So if the repayment plan is prepared, if the claim is filed only by 3 creditors, all the 3 creditors are mentioned in the repayment plan, and 75% voting share with the repayment plan has been approved, then it is binding on those 3 creditors. So in case there are some creditors who haven't participated into the insolvency resolution process, those creditors would still have their claim on the debtor. I'm only talking about the insolvency resolution process. I'm not talking about the bankruptcy process. In a bankruptcy process, all the creditors, once the discharge is given, all the creditors would actually have no claim on the debtor after the bankruptcy. However, insolvency resolution process is specific to those creditors who are part of the resolution process, who are part of the repayment plan, who are mentioned in the repayment plan. So this clarity is very important. Bankruptcy process, where the debtor is completely discharged from all past liabilities except for those liabilities which has been all kind of debts which has been raised fraudulently. However, in the case of insolvency resolution process of personal guarantors, the repayment plan is binding only on those creditors who participated into the repayment plan and who are mentioned in the repayment plan. So this part is very important. So there is a different discharge. There's a different discharge given to debtor after the successful resolution process, and there is a different kind of discharge given to bankrupt after the bankruptcy process. I will come to those discharge sections so that we understand both the processes. I clearly said that unless we understand bankruptcy process, nobody would come forward for the insolvency. Presently, the banks are coming forward for the insolvency because they've been directed by the Department of Financial Services, Ministry of Finance, that you should proceed against the promoters who have given guarantee. However, when the debtor will start coming under this process, they would come because they want the discharge from the past defaults. So therefore, the bankruptcy process is more important to understand. And after that, we will actually come out with 2 sessions for bankruptcy process. Now, the repayment plan is rejected by the adjudicating authority under section 114. The debtor and the creditor shall be entitled to file a bankruptcy application. That, of course, is valid. In case the repayment plan is not accepted by the adjudicating authority, the bankruptcy application can be filed. Copy of the order of the adjudicating authority shall be provided to IBC for entry in the register. So now we have seen the repayment plan is approved. Repayment plan is binding on the creditors whose name is mentioned in the repayment plan. That means their claim has been filed. They are part of the process. Now let us understand the implementation and supervision of repayment plan dealt by section 116. RP shall supervise the implementation of the repayment plan. RP may file an application to AA for directions for any matter arising out of implementation of repayment plan, and AA may give such directions. Now, this is an additional responsibility on RP to supervise implementation of repayment plan. I would just caution all the insolvency professionals that when you take up this implementation as part of your scope of work, then you are entitled to a separate fee for this scope of work. And this fee also would be provided in the repayment plan and would be paid by the debtor. So this fee cannot be the fee which has been given to you for the assignment of resolution professional. This you have an entitlement to have a separate fee. Now, once the resolution repayment plan is being implemented, there can be 2 scenarios. One, that the completion of the repayment plan, which is dealt by section 117. In case the repayment plan is completed successfully, RP to forward within 15 days of the completion of the repayment plan to all persons bound by repayment plan and AA these documents. What are these documents? These documents is notice that repayment plan has been implemented fully. Report of the RP showing all the receipts and payments made as per the plan and extent of implementation. Comparison of implementation with the repayment plan. So this has to be done by the RP within 15 days of the completion of the repayment plan, and all these documents are required to be submitted to AA. Time of 15 days can be extended by 7 days by AA after moving an application. Of course, like application and that too for 7 days, nobody would opt for it because the NCLT may take even more days to allow that 7 days. So at this part, section 117 deals with the completion of the repayment plan. That means that the successful completion of the repayment plan. Section 118 deals with repayment plan coming to end prematurely. Now, the premature end of a repayment plan, and that means the repayment plan not fully implemented within time as per the repayment plan, RP needs to prepare a report again and shall submit to AA showing receipt and payment and reason for premature and details of the creditors whose claims are not fully paid as per the repayment plan. This report has to be submitted by the RP, and then AA shall pass the order of the repayment plan has not been fully implemented. That order of the AA that it is not fully implemented, then thereafter the debtor and the creditor whose claims are not fully paid can make an application for bankruptcy of the debtor. In that case, the AA shall forward RP report, then the adjudicating authority order to all persons bound by the repayment plan, including debtor and creditor, and 1 copy to be forwarded to IBC. So that's the premature end of the repayment plan, where the repayment plan has not been implemented successfully. It got almost closed because there was no possibility of getting it implemented further. Receipt and payment, the creditors, all that has to be attached, and the RP has to prepare a report, and then adjudicating authority also has to prepare an order. That order has to be forwarded to or served on RP on all the persons who are bound by the repayment plan. Now coming the main subject, which is a discharge order. As I said, there are two sections dealing with the discharge of debtor from liabilities. One is section 119, which is consequent to successful implementation of the repayment plan. The other is section 138, that is on the bankruptcy of debtor. The discharge order under section 119, it has to be applied by the RP. RP has to apply. Now, look at a scenario that in case a repayment plan has got a term of 3 years, first the RP started the process of insolvency resolution when the NCLT appointed him for the purpose of report under section 99. After the report is considered by adjudicating authority, the commencement of insolvency resolution process starts. It continues for 180 days plus any delay before NCLT in passing the orders. Thereafter, the repayment plan implementation will start. If the repayment plan is for 3 years, the RP will continue for 3 years, will monitor the repayment plan, and finally, it is the duty of the RP to apply for the discharge of the debtor to the adjudicating authority, and only to those debts which are mentioned in the repayment plan, not all the debts. So there are 10 people who has given loan to the debtor, only 3 participated into the repayment plan. The discharge is available only for 3. 7 people who have not participated into the insolvency resolution process of the individual, they can still go and as a creditor, they can still file an application after this resolution, after this repayment plan is completely implemented. So then the repayment plan may provide for early discharge or discharge on completion of the repayment plan because there are possibilities. There are possibilities that there is the property available with the debtor as an illustration, and that property would be given to one of the creditor, and then the debtor would be eligible to apply for an order of discharge from debts. It may be different that still the property has not been sold, still the money has not been recovered by the creditor, but that can be part of the repayment plan, that early discharge would be available to debtor. In that case, the adjudicating authority may pass order of discharge, and a copy shall be forwarded to IBBI for making entries. Now, this one, as far as the section 119 is concerned, this actually would this discharge would be as per the repayment plan. A repayment plan means, one, that it is only from the debts who are part of the repayment plan. Number 2, an early discharge is also possible in case it is part of the repayment plan. Number 3. Now, when we consider section 138, which is a discharge after the bankruptcy process, that is the fixed period. Once the bankruptcy is commenced, after 1 year of commencement of bankruptcy, the discharge would be given to, the discharge would be applied to NCLT, and or earlier in case the committee of creditors, which is constituted during bankruptcy process, in case the committee of creditors approve earlier discharge, then it is possible to go for earlier discharge. So, however, not more than 1 year. In any case, not more than 1 year. It is only either 1 year or less as approved by the committee of creditors. That is a position of discharge under section 138 after the bankruptcy process. This order shall not release the bankruptcy from any debt incurred by means of fraud or breach of trust to which he was a party. This section 138 order, that would not give a discharge to bankrupt from any debt incurred by means of fraud or breach of trust to which he was a party. So everything would be cleared. All commercial liabilities would be cleared. Criminal liabilities would never be extinguished. However, all those debts which are incurred by means of fraud or breach of trust, that would also not be cleared. I would actually go a step further, saying like discharge order under section 138, because we are comparing the discharge orders. So let us see what is discharge order under section 138, because this pertains to bankruptcy part of it. So the bankruptcy trustee has to apply for this discharge order. Again, on the expiry of 1 year from the BCD, bankruptcy commencement date. Within 7 days of the approval of the COC of the completion of the administration of the estate, if the obtained prior to 1 year. However, in case any bankruptcy process is completed even before 1 year expires, then the committee of creditor will have to apply within 7 days for the discharge order in favor of the debtor. The adjudicating authority shall pass a discharge order if satisfied, and a copy of the discharge order shall be forwarded to IBBI. Now, what is a discharge order under bankruptcy? This discharge order under section 138 will release the bankrupt from all bankruptcy debts. Shall release the bankrupt from all bankruptcy debts. What we have seen in section 119 is it is only a discharge from those debts which are mentioned in the repayment plan, who participated into the resolution process, and only those one. However, in the bankruptcy, all the debts, bankrupt debt, from any debt incurred by means of fraud or breach of trust to which he was a party, that's the only thing, that this would not be considered as a discharge from the debts incurred by means of the fraud. However, now this discharge order is given to the bankrupt, but the bankruptcy continues. Discharge order is given to the bankrupt, however, the bankruptcy continues. How the bankruptcy can continue? Because the bankruptcy trustee is continuing. Bankruptcy trustee, within 1 year, it is assumed that he has taken over all the properties of the bankrupt. He may take 5 years' time in disposing of those properties and then distributing the dividend to the creditors. However, he may do it in 5 years, or he may do it in 5 months. In case he's doing it in 5 months, then he has to give the discharge to debtor in 5 months. But in case he does it in 5 years, he will have to apply for the discharge after immediately on completion of 1 year from BCD, bankruptcy commencement date. So this is something which is very important part, and the difference of the effect of discharge under section 139 is that the bankrupt shall release this discharge under section 139 shall release the bankrupt from all bankruptcy debts, except one, that the debt incurred by means of fraud, two, from the excluded debts. So we had seen excluded debt, in case you would recall, that the fines, penalties, all that was excluded debts. So this discharge will not affect functioning of the BT, and the bankruptcy trustee would continue. That's very, very important part, that bankruptcy trustee would continue and the discharge would be given to the bankrupt. So let me see in case there is any question in the chat box. So let me see, the questions are...
Sir, one question from Mr. Devesh, question pertaining to webinar part 1. So he's asking, under the definition of excluded assets, can there be any limitation to the amount of life insurance policy being excluded? In case there is not any limit, hypothetically, one can save his asset from being taken by creditors.
Certainly, I think this is a good question, but that is one reason that when these life insurance companies, when they would start the process of insuring any life of a person, they would beyond an amount, they would seek the information about the profile of the person. You can try. No life insurance company can give you an insurance of 10 crores in case you have no matching income. The life insurance company will understand the value of your life based on your earning capacity. That is the maximum amount of insurance which will be available to you. So it is not correct that a human can get himself insured for 100 crores of rupees. It is not possible. Human can get his life insured only to the extent which is justified based on his earning capacity. So yes, this, as far as the question is concerned, that's very good. That yes, in case whatever money is invested in life insurance, that would be saved, that would not be taken away by the bankruptcy trustee, that would be available with the bankrupt for the rest of his life. Nobody can take it away. What are the other questions, Rohit?
Sir, another question is the repayment plan for personal guarantors has to be in the line with the resolution plan of CIRP?
No, a resolution plan under CIRP is a totally different concept. Repayment plan is a totally different concept. I have explained one, that the resolution plan is final and it is binding on all as per section 31 of IBC, whereas the repayment plan is only binding on those creditors who participated into the repayment plan and whose name is who are mentioned in the repayment plan. Repayment plan can also be but see, it is based on what the debtor can offer, based on his assets, based on his security interest. However, the repayment plan can also do all such things as resolution plan can do: haircuts, deferment, security changes, change in the security interest, further funding. Everything can be done as it is possible in resolution plan, in repayment plan also.
Okay. One question.
Any other?
Yeah, there are a few more questions. One question from Mr. Kanan. If the PG transfer all the money to pension fund, what action can we take?
No, as I said, the pension fund and the life insurance, both are not unlimited. Both are such investments which are coming with some restrictions on individual to individual. So it is not possible that a personal guarantor can transfer all funds into pension fund or life insurance fund. That's not really possible. So yes, in case, to the extent the funds are accepted by pension funds, those are outside the bankruptcy, those are outside the bankruptcy trustee's approach. The bankruptcy trustee has to leave those assets as excluded assets. So those are excluded assets, so cannot be attached.
Another question from Mr. Nitish Saxena. Would all the suit civil cases against bankrupt guarantor finish after he is declared bankrupt?
Yes, not not in the discharge order under section 119, but yes, when the discharge order is available to bankrupt under section 138 after the bankruptcy process, then all civil liabilities would be extinguished and the bankrupt would start a fresh commercial life. He would be, within 1 year of the commencement of bankruptcy process, he would be completely a fresh commercial man. He would own assets. He would own his own house in his own name, and no old creditors can sue him to recover that money from his current assets, from his present assets. Yes, Rohit.
Another question, sir, what about investment in PPF? Is it part of excluded debt?
The PPF is not part of the excluded debt. PPF is an investment like FDR. It is an investment with post office, or now I think banks are also doing it. So PPF is not an excluded asset.
Okay. How about
under section 79, subsection 14?
How public announcement is updated in the website of AA?
The adjudicating authorities are in fact gearing up. They have a place in their offices to demonstrate some of the public notices, they also can come up with some kind of website. But however, till the time such infrastructure is created, the adjudicating authority is directing the RP to release the public notice. In fact, when I was doing my part 2, in fact, I read those rules which are made by Ministry of Corporate Affairs, where the adjudicating authority has been empowered to direct the RP for such publication of notices till the time the infrastructure is developed.
Another question from Mr. Parthasen: How the BT ensures inclusion of all assets of the PG?
The bankruptcy trustee would have various sources of information. One source would be because in case you would see the claim forms which will be submitted by the creditors, the claim forms are in fact asking the creditors to provide information about the bankrupt, information about his family, information about his businesses, assets, whatever information that creditor has, it is required that the creditor would provide that information to BT. BT can also appoint, in case the funds permit or in case the committee of creditors would permit, appoint another professionals which are called detective agencies. And the detective agencies also can be appointed, and the detective agencies can give a report like what are the affairs of the debtor, what are the affairs of the bankrupt, how and what kind of businesses that he's handling. And this kind of report also would help to trace the assets of bankrupt. Some softwares are also available nowadays. Those software provides the information about related parties, related organizations, and some other informations about the bankrupt.
Another question from Mr. Chandrasekhar: if debtor not cooperates with the RP, can do other than asking for bankruptcy process?
If the debtor is not cooperating, then there is a section available. There is a remedy available with the RP. RP can file an application, as we file an application under section 19(2) of IBC. In this case, also the RP can file an application seeking directions to debtor from adjudicating authority for cooperation or for providing specific information. And in case the debtor is not cooperating, that means that he is not interested in giving or submitting any repayment plan, then the creditors definitely can decide, or RP can decide there is no repayment plan, so the RP can submit a report. So see, the resolution process is made in such a manner that if the debtor is not coming forward, if the debtor is not even traceable, then the RP is not supposed to have a meeting of creditors. The RP can say that there is no repayment plan. RP has not even able to find the debtor. So if the debtor is not available, there is no repayment plan. So there is no possibility of a meeting of a creditors. So therefore, the report of the RP would say that no meeting was summoned. Therefore, the resolution process may be closed. That's what is the RP's duty. But however, practically, I feel that the RP will have to conduct the meeting of the creditors. The first meeting of the creditor the RP will have to conduct is only to get his fees approved and the other insolvency resolution process cost approvals. So even for appointment of any professional, although during this insolvency resolution process, there is no requirement of appointment of any professional. No requirement, because I don't think any professional is required to be appointed for during this process. And it is only few reports that the RP has to prepare. And if the debtor is not cooperating, no repayment plan. If the debtor is not cooperating, no statement of affair. Simply report, and finally the insolvency resolution process is closed. Not much of work. The only thing is that there is hardly any work in the insolvency resolution process. And similarly, the fee is also not good. The recovery of the fee from the creditor is a challenge. There is no precedence so far that who would contribute. The person who is appointing you is a different person. The person who will actually become creditor in this process will be different. The creditor will say that I am not getting anything, I am not contributing anything. So these are practical difficulties. However, for RP, I would only come down to that, because let me first of all try to explain you the undervalued transactions and the extortionate transactions or the preferential transactions. So these are important. You see, like in case we have some more questions, we'll take it up later, Rohit, and let me finish up this part.
Sure, sir.
Okay. You take a watch on the questions and I will take it later. Now let us discuss the undervalued transactions under section 164. One, I would be very clear that during insolvency resolution process, no avoidance transactions are supposed to be looked at. No avoidance transactions are supposed to be looked at by the RP. It is only and only the job of bankruptcy trustee. I'm only attending to this part because this is important for anyone to understand that this is not a part that we are supposed to look into during the insolvency resolution process. It is only the bankruptcy trustee who can actually apply to adjudicating authority for any such transactions between the bankrupt and any other person. Undervalued transaction between the bankrupt and any other person, not between the debtor. It is only between the bankrupt. Look back period is 2 years, ending on the date of the filing of the bankruptcy application. Filing of the application, not the commencement of the bankruptcy. Filing of the application, not the commencement of the bankruptcy. Look back period is 2 years. The transaction should have caused bankruptcy process to be triggered. Any transaction between the bankrupt and its associate would be deemed as undervalued transaction. So this was when I was explaining the concept of associate. I said all transactions entered with associates would be considered as undervalued transactions and would be reported to adjudicating authority. Then the adjudicating authority would decide whether there is anything which is undervalued or not. But then the bankruptcy trustee will definitely report the transactions as undervalued transaction if it is between the look back period and if the transactions been entered between the bankrupt and the associate. Transactions in the ordinary course of business is exempt. That's not considered to be undervalued, but this is not applicable to the transactions with associates. Now, if I'm in a business of construction, I'm constructing flats. And within 2 years before my bankruptcy starts, if I sell most of my flats to associates, that also would not be considered as ordinary course of business. That would also be considered as undervalued transactions. What are the nature of undervalued transactions? Is almost similar to section 45. He makes a gift to that person. No consideration has been received from that person by bankrupt. It is in consideration of marriage. Consideration is less than the market value. The order can be passed by the adjudicating authority, where the transfer can be held as void, or we can say that the property which has been transferred to other person, that actually would be back to bankruptcy trustee. The original status can be restored. Original status of the transaction can be restored. These are the 3 remedies available. Gift are considered undervalued. No consideration again is a undervaluation. Even if somebody says that I broke my marriage, so therefore I have given all my properties to my ex-wife, that is also considered undervalued. And where the consideration is less than the market price. So all these are undervalued transactions, and undervalued transactions are to be reported to adjudicating authority by the bankruptcy trustee and not by the RP. So this process I am only attending, although this is a process that I should have attended in bankruptcy trustee, but there are a lot of questions which are coming, what kind of avoidance transactions that we have to handle. So the RP is not supposed to handle any kind of avoidance transactions under section 164 or 165, none, nothing. This is not your role. Your role, it is the role of the bankruptcy trustee. It is the role of bankruptcy trustee. So coming to the preferential transactions or transactions under section 165, it is also for the bankruptcy trustee and not for the RP. The look back period is 2 years from the date of filing of the bankruptcy applications. For any preference given to an associate, 2 years. Look back period is only 6 months for any preference given to any other associate. Now, let us go back. For undervalued, the look back period is 2 years, irrespective of whether the transaction has been entered with associate or any other person. However, the transaction within 2 years with the associates would be considered as undervalued without even considering the value of the transfer. In the case of preferential transactions, if the transaction is with the associate, then the look back period is 2 years. If the transaction is with any other person, then the look back period is only 6 months. Transaction giving preference should have triggered bankruptcy process. AA can pass the order, declare the transaction as void. Property transferred to vest with the bankruptcy trustee and form part of the bankruptcy estate, restoring the original position. Now, the transaction should have been entered with creditors, surety, or guarantors. So this is a condition in section 43 also. Same condition, that the transaction must have been entered with creditors, surety, or guarantors. Then the transaction must have put that person in a better position. Transaction must have put that person in a better position as compared to his position as per law. Protection of third-party interest in properties is provided, and that of course is provided in section 43 also, in case the transaction is in good faith or it is for value or without any notice of the nature of transaction, without notice of bankruptcy application of the order. So these are the basically brief of the undervalued transaction or the preferential transaction. And of course, the last transaction is extortionate credit transactions. This is section 167. This is also applicable to bankruptcy trustee and not to RP. Extortionate credit transaction, the look back period is 2 years. The terms of the transaction providing credit should be exorbitant and unconscionable under the principles of law. And the adjudicating authority can pass the order in case we file an application, set aside the debt, change the terms and the condition to a little more reasonable. Also, like ask the person to refund the extortion money, surrender to BT any property. So again, this is not applicable to regulatory financial service providers, as section 49 is also not applicable. As 50, section 50 is also not applicable to financial service provider. This is also not applicable. So this was the avoidance transactions which are not to be done by the RP. Now, because we've already close to 1 hour, but I would actually be giving this is an information which is very, very important for all the RPs presently who are working or who are thinking of taking up assignments. So what an RP is supposed to make? First of all, the RP has to sign an application. The application has to be through the RP, but the RP is only supposed to sign it. He has not been given any other responsibility. He has to only sign it, and that's a consent kind of form. There is no additional declaration that the RP is making while signing the application. Then thereafter, the appointment will be done by the adjudicating authority. The first thing that he has to do is the preparation and submission of report under section 99 that we've already discussed in the first session. Then final admission order will come from the adjudicating authority and the moratorium under section 101 will start. RP will issue public notice. RP will receive claims and register claims. This is a good work. It depends on the number of claims which is coming. RP will prepare a list of creditors. Then RP will prepare a list of, prepare a statement of affair. Then RP will prepare a repayment plan in consultation with the debtor in case the debtor is coming forward and offering anything to the creditors. Then RP need to prepare a report on the repayment plan and submit that report to adjudicating authority. Then the RP has to summon a meeting of the creditors, and after conducting the meeting of the creditor, the RP will prepare a report on the meeting of the creditors and will have to be submitted to the adjudicating authority. So this is a process which is within 180 days. So now we have finished 180 days because we have prepared a report, and thereafter, in case the repayment plan is accepted by the adjudicating authority, then the other role starts, and that other role is supervise the implementation of the repayment plan. So whatever presently we are quoting to banks, in that fee, what we are doing, we are preparing a report under section 99. We are receiving the claims, registering the claims, issuing public notice, preparing a list of creditors, preparing statement of affair, preparing repayment plan, holding the meetings of the creditors, preparing the report on the meeting of the creditors, and then submitting it to NCLT. This is the job that we actually have to do within 120 days, and rest of the 60 days is basically given to NCLT for approval of the repayment plan. In case the NCLT takes a little longer, that period is accordingly extended. And then starts the supervision of the implementation of the repayment plan. That's a separate assignment that cannot be considered as a part of this assignment, because the supervision will come as per the repayment plan, because the supervision will be mentioned in the repayment plan. The remuneration of the supervisor, RP, that also would be mentioned in the repayment plan, and that will be paid out of the sources of the repayment plan. Then RP has to give a report on full implementation of the repayment plan or failure of the repayment plan. Then RP has to apply for the discharge of the debtor. So the total period of 180 days, and thereafter the implementation period. So this is the total scope of work. The moratorium is slightly different as compared to the moratorium under the insolvency resolution process and the moratorium under the bankruptcy order. In the moratorium under the bankruptcy order, the estate of the bankrupt shall vest with the bankruptcy order. Estate of the bankrupt shall be divided amongst its creditors. The creditor shall not initiate any action against the property of the bankrupt. The creditor shall not commence any legal proceeding except with the approval of the AA. Moratorium shall not affect the rights of the secured creditor unless relinquished in favor of the bankruptcy trustee. No interest would be payable to secured creditor after the bankruptcy order. These are some of the disqualifications which the bankrupt must see. So once the bankruptcy starts, because this insolvency resolution process has to be followed by the bankruptcy process. Once the bankruptcy process starts, then the bankrupt would be disqualified. Any disqualification provided in any other law, such as Contract Act. So there are various acts where the eligible person to enter into an agreement would be mentioned. Like in a Contract Act, it is mentioned that any person who is undergoing bankruptcy process is not qualified to enter into any contract. He cannot be appointed as a trustee in a trust or a state or settlement. He cannot hold a public office for which the appointment is done by elections. So any political person, in case any bankruptcy starts, his political career is paused, cannot be appointed as a public servant, cannot be elected, sitting, or nominated as a member of any local authority. These disqualifications are only and only till the bankruptcy order is recalled or modified, or till a discharge order is passed. So these are the disqualifications of a person on whom the bankruptcy process has been started. Then these are the restrictions. Anywhere, any person who is undergoing the bankruptcy process, he cannot act as a director or take part in formation, promotion, or management of a company. Cannot create any charge on the estate or take further debt unless bankruptcy trustee specific approval. He will inform all his partners that he is undergoing a bankruptcy. Cannot enter into any transactions of rupees 1 lakh or more without informing all the parties that he is undergoing bankruptcy process. Cannot maintain any legal action or proceedings without specific approval of AA in respect of his debts. Cannot travel overseas without specific approval of adjudicating authority. This is something which is a little harsh. Any person who is undergoing a bankruptcy process, he will not be able to travel overseas. These restrictions are only till the bankruptcy order is recalled or modified. That's what we've already seen. So this little bit of bankruptcy, because these are important part, that what I thought I should share with you, effect of discharge, that we've already done. So as against section 53 under the CIRP, corporate insolvency resolution process, we have a priority of payment. We have a waterfall arrangement, and that is provided under section 178. CIRP, the waterfall arrangement, priority of payment is dealt by section 53. It is dealt by section 178. for individual insolvency and bankruptcy. First priority is the cost of the bankruptcy process, fee and expenses, and this also includes the cost of the insolvency resolution process in case it is not paid. Second priority is the workman dues up to for 24 months and the debt owed to secured creditors, and workmen and secured creditors will rank pari passu. Third priority, employees dues for 12 months. Fourth priority, government dues for 2 years. Last is the any other debt due, including unsecured debt. So the only difference that we have seen, the unsecured creditor has moved below the government. Unsecured creditor has moved below the government, whereas in section 53, unsecured loan was above the government dues. So that's the only difference in the priority of payment. Priority, as mentioned in the section, equal ranking, all that is of course similarly. So when I saw the timelines of the insolvency resolution process, assuming the notice would be served for 14 days, application will be filed, maybe 10 days it is taken, commencement of interim moratorium. So this like first 60 days is taken in the first appointment, which is actually more nowadays. In fact, when the application is submitted for and under section 94 or 95, it is taking more time. So by that time, the RP is just holding on that assignment. So when this order will come, he will prepare a report under section 99. Once this insolvency starts, all these timelines that I've written, and 180 days, after 180 days, then the implementation starts. After 180 days, the implementation starts. As we have section 77 to 73 to 79 in the corporate insolvency resolution process, there are separate sections for punishment or prosecution. So that's like under section 184, where the debtor or creditor provide false information to RP, then there is a punishment of 1 year to the debtor and the creditor, and fine up to 5 lakhs or both. When the creditor promised to vote in favor of repayment plan dishonestly by accepting any money or property from debtor, there is a punishment of 2 years or fine up to 3 times of the property accepted by the creditors or both. If IP contravenes provisions of this part, if the IP, this is very important, even to the insolvency professionals, there is a possibility of 6 months imprisonment or fine or both. Punishment to bankrupt for false information or concealment. This is very important. 186. In case he doesn't declare any information, doesn't declare any asset, he conceals any asset, knowingly makes a false representation, willfully omits or conceals any material information, non-disclosure of the details of the properties, then while making an application for the bankruptcy order under section 122, in case he is not declaring assets, or while providing the information to the bankruptcy in the bankruptcy process, punishment for 6 months or 5 lakhs. Now, fraudulently has failed to provide or deliberately withheld the production of or destroyed, falsified or altered books of account, financial information or other records, then punishment of imprisonment of 1 year or 5 lakhs or both. Contravene the disqualification and restrictions under section 140 or 141, like he goes abroad without taking permission, then the imprisonment for 6 months or 5 lakhs, whichever higher. Has failed to deliver the possession of any property comprised in the estate of the bankrupt under his possession or control, which he is required to deliver to bankruptcy trustee, imprisonment 6 months, 5 lakhs or both. Has failed to account for any loss incurred or any special part of his property comprised in the estate of the bankrupt. That's from the date 12 months before the filing of the bankruptcy application. This is basically 2 years. This is a kind of akin to fraudulent transactions. Has absconded or attempt to abscond from the bankruptcy commencement date. Bankrupt shall be deemed to have absconded if he leaves or attempts to leave the country without delivering the possession. Then this is 1 year imprisonment. Fraudulently misapplied, retained, accounted for any money or property comprising in the estate of the bankrupt, has willfully acted in a manner that the estate of the bankrupt suffered any loss in consequence of the breach. So like everyone is saying that these fraudulent transactions are not showing as section 66 is not there, section 66 is not there, but akin to section 69, section 187 is there, where the imprisonment is up to 3 years. So this is most powerful section 187, where the imprisonment is up to 3 years, and has fraudulently misapplied, retained, or accounted for any money or property comprised in the estate of the bankrupt. So this is the bankruptcy trustee shall not liable under this section if he seizes or disposes of any property which is not comprised in the estate of the bankrupt and at the time of. So this part is the offenses that we actually wanted to see. So now, so partly we have handled the some part of the bankruptcy also, because it is important that the bankruptcy should be known, then only the insolvency resolution process can be conducted. So one comfort that I've given to everyone, that this insolvency resolution process is not really very a detailed exercise. It is actually not a very detailed exercise. So what I'm trying to say is in case there is any question, I think we can take up.
Yes, sir.
No.
So, Mr. Kanan, one question from Mr. Kanan: how RP can ascertain the movable asset belong to PG?
As I said, number one, that the personal guarantor has to declare his assets in statement of affairs. So that's the first is declaration. Then the information that you can seek. See, like why it is so important during the insolvency resolution process that you need to trace the assets. It is not important that you should trace the assets during insolvency resolution process. Definitely it is important during bankruptcy process. The insolvency resolution process is a kind of voluntary process where the debtor will come forward with the repayment plan. The creditor will accept that. So in case there is no repayment plan, then the RP is not supposed to trace the assets. RP will trace the assets in bankruptcy process. RP during bankruptcy process will find information from detective agencies that the bankruptcy trustee may engage. There are larger prosecution provisions in case the bankruptcy trustee does not provide information. So those kind of applications can also be filed that he has not submitted the complete information. He will submit his bank accounts. He will submit his section 26 AS. At least some transactions would be known. See, as far as this immovable properties are concerned, I don't think that I have any answer to this. Like, how do I find immovable properties owned by Mr. A? That kind of scenario is not available in the country. That if I want to understand what are the assets of Mr. ABC, that's not possible. It is only detective agencies, self-declaration, information to be provided by the creditors, by the claimants, all that collectively. And in case later on, any such asset is found, which was pre-owned before the bankruptcy, that of course would be considered as very, very heavy on the bankrupt. Now think of a situation that the discharge has been given. After the discharge, if somebody finds that this property was available with the bankrupt and it was available during the bankruptcy process also, and he did not declare, immediately that property would be captured, immediately the punishment would be started. What is exempted? Exempted is that all the debts would be exempted after the discharge order. But it is not exempted that you still continue to own those properties which you owned before the bankruptcy order, which you did not declare. Those properties will continuously fall under the threat. Anyone who actually would have an information that this is a property which was not declared by the bankrupt and he has got a discharge order, immediately anyone can file an application that this property also belongs to the creditors. What are the other questions?
Another question is from Mr. Pavan. Can a related party can be included in unsecured debt?
Related parties definitely can be included in the debt part of it. They can be made as they can be also paid in the repayment plan, but they would not have a right to vote on the repayment plan. Related parties, which are called associates, they would not have a voting right, but yes, they would be entitled to the repayment of their debt in case the funds are available with the debtor and he is ready to offer.
Another question from Mr. Durga. What is the difference between administration of estate and distribution of asset?
Administration and distribution is one process where the bankruptcy trustee will take control and custody of all the assets, would try to sell or realize, and in case the assets are not realized, then there are processes where the assets can even be distributed to the creditors. So the administration and distribution, the administration includes the control, custody, sale, and distribution includes if it is even the sale proceeds or assets of the bankrupt can be distributed.
So another question, Ms. Elga, in individual insolvency, how can an RP analyze if he will get his fees in the case or not?
RP has got nothing to analyze this because the creditor who is appointing the RP, it would be their responsibility to make payment. The only concern that I have, like for example, banker A appoints you, and when the claim will come from 4 bankers and some of the operational creditors, then every creditor will say that I will contribute only to the extent of my debt, proportionate to my debt. I will not contribute the entire fee of the RP or all the expenditure. So that would be a concern. Some people would not contribute, some people, because the money would be too small and it would be really difficult to go to NCLT and to seek directions. So these precedences has to be established. And unless these precedences, some judicial pronouncements will come, then the fee recovery would be easier. For the time being, the fee recovery would be it would be a challenge.
Another question from Mr. Chandrasekhar. Can RP investigate the asset and depth of debtor during resolution process or just to accept whatever debtor furnished to RP?
No, it is not required to be done by the RP. RP is only preparing a repayment plan. It is a voluntary process. In case the debtor is not declaring, definitely the repayment plan would not be accepted. And once the repayment plan is accepted, it is also binding only on the creditors who participated into the repayment plan, who are mentioned in the repayment plan, who have submitted their claim. So the other creditors who have not participated, they can still come out with an insolvency, another insolvency of that individual. So it is not required for the RP to trace the assets of the debtor in the resolution process.
Okay. Another question from Mr. Sunil Datta. Is there any provision from extension beyond 180 days, as in case of CIRP up to 330 days?
There is no provision in the law. However, this 180 days includes 60 days for NCLT to approve a repayment plan. For the RP, the period is only up to 120 days. In case within 120 days, the RP is not able to submit a repayment plan, then repayment plan cannot be submitted. And in case it is submitted, then further 60 days is kept. In case that further 60 days exceeds, of course, then it gets automatically exceeded. However, the moratorium would, as I understand so far, the language is very clear that the moratorium would end on 180 days. However, if the NCLT would not pass the order for approval of the repayment plan or rejection of the repayment plan, my understanding is that the moratorium would continue till the time the order is passed by adjudicating authority. Automatic extension would be given beyond 180 days only for the NCLT to pass a resolution plan, approval of the repayment plan.
Another question, can RP has any control over bank accounts of the debtor during resolution process?
No, it is not empowered. RP will not have control over the bank accounts of the debtor during resolution process.
Can debtor travel abroad during the resolution process?
Or the debtor can travel abroad during the resolution process, but not during the bankruptcy process.
Another question from Yogendra Pal, whether there is any provision to get valuation of properties of debtor under bankruptcy from under bankruptcy? Yeah.
There is no requirement. However, However, the secured creditor might get of their own, might get on their own some valuation to submit their claim, where they would actually submit the secured portion separately or unsecured portion separately. So they may have their own valuation. So there is no requirement under the provisions where the RP is required to get the valuation for the assets of the debtor during insolvency resolution process. No requirement.
Another question from Mr. Chandrasekhar. Can debtor sell his properties during resolution process?
No, he cannot sell his properties during the resolution process. He can only offer in repayment plan. He cannot sell. This is part of the moratorium under section 101. Okay.
Another question from Mr. Nitish Saxena. What criteria to keep in mind while fixing fees of RP? Because the duties of RP during PIRP are much less than CIRP.
No, this is not PPIRP. The duties are much lesser. I think that is the reason then the banks are not offering more than 50,000 rupees per month per assignment, and they are also restricting the payment for 6 months. So I consider this remuneration is reasonable because the duties of the RP during insolvency resolution processes are also limited. I have given a complete chart of the duties, and these are limited duties. And I would be very happy to take up the assignment, like everyone would be happy to take up the assignments at 50,000 rupees per month, because that's reasonable looking into the scope of work of the RP.
Another question from Alkaji. Can IP be changed during implementation of resolution plan?
Yes, during the implementation of the resolution plan, which can be part of the repayment plan, that the RP for implementation would be different, and that can be the condition of the creditors who are approving the repayment plan, that for implementation, we would like to have a different RP to monitor the repayment plan, and that has to be voted by 75% of the on the value basis. However, during the insolvency resolution process, there is no, the RP can be replaced, but without the choice by the debtor or the creditor. In that case, the adjudicating authority will pick up the another name from the panel maintained by them. It is not provided that the creditor can choose another person and or debtor can choose another person. However, both can make an application that we want to change. Change means another person which may be picked up by NCLT from the panel.
So we have covered all the queries.
So great, thank you very much. So we have covered in 3 sessions the insolvency resolution process. We have covered the avoidance transactions. We have covered some part of the bankruptcy, the restrictions, the disqualifications, and I have given a complete detail of the total scope of work of the resolution professionals during insolvency resolution during insolvency resolution process of personal guarantors. So this was my objective achieved. Thank you very much for being connected with me. We will come up with the bankruptcy process in 2 sessions, or maybe depending upon the total length of the subject, and that would start from next Sunday, not this Sunday. That will start from next Sunday, and again 11 a.m. So thank you, Rohit. You should prepare another banner for next Sunday, which will be complete understanding of the bankruptcy process. Thank you very much. As I said, this is my way of learning, and I'm obliged to you all who are getting connected with me. And when I see huge numbers of people, in fact, I get motivated. Thank you very much, and have a very good night. Thank you.